Hello, 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 and welcome everybody. Okay. We're going to wait for a bunch of people to get in so I don't have to keep repeating everything. So once a bunch get in, please, while you're waiting, smash that like button. Let's get it out there so we can get started. Got lots of viewers in and not so many likes. Let's smash that like and let's get it out there that we are live with this. That way we can get going and we don't have to keep repeating it. And it does help the channel and shows your appreciation for what we're bringing you. So thank you, everybody who has smashed that like button. And W Love, hello and welcome. Good to see you. Like I said, as soon as we get a bunch in here and the likes are up, we will get started. The judge is not happy with Ann Taylor, you guys. Thank you, Missy RN, and welcome. Good to see you. Okay, let me just make sure I've got the ones up so far. I can only pull so many up at the same time, you guys, because I don't want to slow down my computer here. But we're going to go over this, and the judge is not happy. The judge is not happy with Ann Taylor. Ann Taylor's not going to get away with the stuff that she's been getting away with. Now, I want to make it clear that right now, the things that you're about to see, Ann Taylor filed all these motions before the judge gave her a slap, you could say. So I'm going to be anxious to hear what the judge has to say about all these motions. Now, I'm also going to tell you, we're not going to read through every single one. I will scroll it. So if you do want to read through, because true to Ann Taylor, some of these are 80 pages long and it's just very repetitive. But I will bring you the information as to what's going on and what it means. Okay. So right off the hop, let's get going because this is interesting, you guys. Very, very interesting. So one of the motions that were filed, and like I said, before the judge gave Ann an ass wipe, I mean, a slap on the butt, she filed all these motions. Now you can see that all these motions were filed on either the 13th or the 14th. Okay. Those are going to come into play and it's going to explain a lot. Okay, let's go. The first one, defendant's motion for leave. Comes now, Bryan C. Kohberger, by and through his attorneys of record, and hereby moves the court for a leave from the court's order governing further criminal proceedings and notice of trial setting. Specifically, the discovery motions deadlines of November 14th. Look at this, you guys. She files this late afternoon on the 13th because the judge had already set his scheduling order and the defense had to file their information, okay, before the 14th of November. She files and asks for this leave on the 13th, late afternoon, 3:01 p.m. Idaho time. Okay, very sneaky. Okay, very sneaky. K. Mitch, hello, my dear. So she files this defendant's motion for a leave. Specifically, the discovery motions deadlines of November 14th, defense counsel and investigators have not had finished. This makes no sense. And you guys know with it, because I worked in the legal field over 30 years in criminal law, this irritates me. And there's a lot of this. Either words misspelled, words missing, words, a sentence that doesn't make sense. Defense counsel and investigators have not had finished. Doesn't make any sense. Anyway, a full review of the vast amount of discovery in this case and will continue to do so. Counsel requests that this motion be set for a hearing in order to present oral argument, evidence, or testimony in support thereof. And I want an hour to give you the reasons why I shouldn't have to have all my discovery filed the discovery motions before November 14th. She files this late afternoon on the 13th. It's due by midnight, right? So I'm going to jump to this. I'm going to jump to this right away. Order denying motion for leave. Okay? Before the court is defendant's naked motion for leave, November 13th, 2024, in which he seeks relief from the discovery motions deadline of November 14th, as set forth in the governing scheduling order. So they knew long ago that they had to have this in by the 14th. The judge is going to explain why he is pissed. Defendant asserts his counsel and investigators are still reviewing the vast amount of discovery in this case, and therefore he needs additional time to file motions related to discovery. But the prosecution's done it, and done it on time. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. He is pissed off. The state's discovery deadline was September 6, 2024, and they met that deadline. Defendant could have ascertained far sooner whether the discovery motions deadline would pose a difficulty and brought it to the court's attention. Further, and importantly, the defendant has not demonstrated with his filing good cause to enlarge the deadline. He has not set forth what efforts have been made to review the discovery, what portion of the discovery has not yet been reviewed, and why it has not been reviewed, or how long it will take to complete such review. Consequently, this motion is denied. So this is what he means by the naked, right? You gave no reasons for anything. Just, I got so much I got to go through. I need more time. But do you see this right here? Motions to enlarge a deadline filed on the eve of the deadline are not well taken, and you have been denied. So they right now are in violation of their deadline. You can't file on the eve of the night before your deadline. You got to give enough notice. And they've known since September, right? So we'll get rid of that. I think this was the leave. Okay, so we can get rid of that one. Let's go to the next one. Then she files, and as you guys can see, look at this. She has filed a lot. We're going to go through it all. Okay, so the next one. Motion for Frank's hearing. So now she wants a Frank's hearing. We get tidbits. There's some of these, you guys, that I'm going to read because we get some tidbits of information in them. Now, the ones that are like 80 pages long, I'm not going to go through. You know Ann Taylor. She's got to cite laws from 1988. She's got to cite cases from 1972. We're not going to go through all that crap, but we will go over the main parts. I will scroll through. So if you do want to read it all from top to bottom, you can do it and pause it. Exactly, K. Mitch. Okay. So now they are asking for a Frank's hearing. A Frank's hearing is generally when they feel that either an officer, law enforcement, has done something that shouldn't have been done. Okay? So let's read through this is only 2 pages, so we will read through this one. Comes now Bryan C. Kohberger, by and through his attorneys of record, and moves the court to conduct a Frank's hearing. This motion is made pursuant to the 4th Amendment of the United States Constitution, Article 117, the Idaho Constitution, and Franks versus Delaware, 1979. A proffer and exhibits are filed, contemporary, I'm not even going to try, in support in accordance with State versus Fisher, Idaho 365, 204, and 2004. The parties stipulate to the sealing of the proffer and exhibits. So it has been sealed The prosecution agreed to file all the exhibits and that under seal. The seal proffer and exhibits are being provided to opposing counsel. Hang on. As soon as I'm done. Okay, where was I? The under seal proffer and exhibits are being provided to opposing counsel and court staff via email on the date of this motion. Hand delivery to the court in person. Filing will occur no later than November 18th. So they want a Franks hearing. Now, all the exhibits and everything that they are complaining about is all filed under seal. But we're gonna learn a little bit about what they're complaining about. What's this one? Okay. This one. Okay. So we're gonna do this one next. We'll get rid of this. We're gonna do this one next. Now, they have fought this before and they lost. Okay? They fought this with Judge John Judge. But they're going to try it again. And if they think that the judge is not going to catch on to this, they're sadly mistaken. So now they are filing another motion to suppress, and this is going to come into play with everything else we're going to look at today. Okay? Comes now Bryan C. Kohberger through his attorneys of record and moves to suppress all evidence illegally gathered by law enforcement using his genetic information. This is why they are calling the Franks hearing. They want the Franks hearing first because they're going to say that law enforcement illegally gathered all of this evidence. So they want every piece of evidence in this case tossed. Well, not the stuff from 1122 King Road and other stuff like that, but anything regarding Bryan Kohberger, any evidence they've gathered regarding him personally, they want it all thrown out because they got his the lead on him from IgG testing. Well, IgG testing has been used, and this was already fought with Judge John Judge, and he had said it's coming in. Okay, so they're trying it again. They're saying that they want to suppress all evidence illegally gathered by law enforcement using his generic information. Now, the thing is, did they get a lead on the FBI? Got a lead because they submitted it to the IgG information bank, and they got a hit that whoever's DNA was on that sheath, on the snap of the sheath, was a male offspring of Bryan Kohberger's dad. I forget what his first name is, but Mr. Kohberger, okay? His father. Well, his father only has one son and two daughters. It's a male offspring of his father. So then when they arrested him, they did the buccal swab in his mouth. It matched perfectly the DNA that was found on the knife sheath. So, but they're saying that because they got the lead naming Bryan Kohberger's father, that it's one of his children, a male child of his, that's DNA is on the knife sheath, okay? Hey, Rose, how are you, my love? I haven't seen you in a while. Hope you're well. This motion is made pursuant to the Fourth Amendment of the United States Constitution and Article 17 of the Idaho Constitution. Now, this has been fought about many times in the courts, you guys. And, okay, Mitch, I don't know what you mean, Brian. I don't know what you're talking about. I forget what his dad's name is. Thank you, Rose. I appreciate you. Hello, Isabel. Okay, so a memorandum and exhibits are filed contemporaneously in support under seal. This motion is being filed under seal pursuant to the Honorable John Judge's previous order. See how she's bringing that up? No, Bryan Kohberger's father's name isn't Brian. Hang on. Let me find out. Hang on. Bryan Kohberger, father's name. Michael. His dad's name is Michael. Okay, so when they did this IgG testing, put that sample from the knife sheath through IgG data bank, it came up a hit to Michael Kohberger, and that the DNA on the knife sheath would be one of his male children. Okay, so his name is Michael. I got to write that down because I will forget. Michael Kohberger. So that's how they, they had the video of this Hyundai, right? They already had that. So when they started looking into Bryan Kohberger, okay, that's when they seen, oh, he lives in Pullman, Washington. Oh, he has that white Hyundai with no front license plate. We'll go through it. Thank you so much, Rose. I appreciate you. Dosia do. Hello. Isabel, hello. Oh, I miss you too. That was a faraway guess. Leslie, hello. Once rubbish is in a bin, it's free for all. He took rubbish out wearing gloves. Yeah, but what it was they initially got the lead towards Bryan Kohberger through the IgG testing because it came back to it was an offspring of Michael Kohberger. It was a male offspring of Michael Kohberger. When they started investigating that, they found that he only had one son, and his son's name was Bryan Kohberger. They started investigating Bryan Kohberger. They found that they already had the video of this white car. Bryan Kohberger had that white car, that white Hyundai Elantra. Then they started looking into the stops that were made. They got his phone number. They started, checking his phone number, seeing that he was in the area, all that stuff. It started with that. So they're saying, nope, they can't use it, right? Yes, they got it from the knife sheath. And then don't forget, we'll get there. We'll get there, you guys. I'm going to try and go through these in order so I don't confuse myself more than anybody else. But yeah, there's steps that they took. Once they got the IgG back and found out it was Michael Kohberger, they investigated Michael Kohberger, found out that he only had one son. That son's name was Bryan Kohberger. When they started looking into Bryan Kohberger, they found out that he lived in Pullman. He owned a white Hyundai, and that he had been stopped, and he provided his phone number and address to the police that stopped him for these traffic stops, right? We remember seeing the videos on that. So with that phone number, they got a search warrant for his phone number, and they started seeing, was he in the area? And that's when everything started coming together. Okay. But we'll get to that, you guys. It all fits. Yes. And then once they had their suspect, Bryan Kohberger left Pullman and went back with his dad to Pennsylvania. He was trailed all the way back to Pennsylvania. Once he got there, that is when the FBI had him under surveillance, and they went and they took the trash. They seen him throwing his trash away in the neighbor's bin. They seen that his trash was put in separate little baggies, that he was wearing gloves, stuff like that, and put in the neighbor's bin. That's not what a person not guilty does. Why are you doing that? And the interviews with the sister says he's never done that before. He was wearing gloves inside the house. They seen him cleaning out his car with bleach, all kinds of stuff, right? So it does. But what they're saying is, because they got his father's name through the IgG, it's illegal, which it's not, because police forces have used this for years and it's always stood in court. So what she's trying to do is, the Honorable Judge Judge, as you see here, she already tried this with him and it didn't fly. So now she's trying it with Judge Hippler. But don't forget, she wasn't slapped by the judge, and the judge didn't put her in her place until after all this was filed, because this was all filed at once, you guys. So he's already replied to her motion for leave, and he says, no, you're not going to file the night before and expect me to give you this leave. No, that's not what you do, and that's not how it's done. Like he gave her, you might as well say he gave her a slap and said, you ain't pulling that crap with me. Okay? So, again, she's trying to do something that was already thought. So anyway, related to this motion be filed under seal until the court could review and the issues and arguments filed. The under seal memorandum and exhibits are being provided by to opposing counsel and court staff, and that they'll hand deliver to the court for in-person filing will occur no later than the 18th. This was also filed on the 14th. She filed a ton of this stuff. Okay, so this is her motion to suppress the genetic information. Now, she's hoping that the judge will say, oh, yeah, you can't do that. You can't do that. No, I'm going to grant you this. So what she's hoping is the judge grants this, because every motion that she files after this is 18 pages, you guys, is related to, okay, which one is this? Okay, let's start over here. Every filing that she filed, and we're here, okay? All these filings for Amazon, for his apartment, for Apple, for the arrest warrant, for AT&T, for cell phone data, for Google information, for the pen trap trace device, for the person in Idaho, a person in PA, for the white Hyundai and his parents' house. She's saying all of this has got to be thrown out because they couldn't use the IGG. They wouldn't have got all this information without the IGG. So that's what she's trying to fight. So the first one, again, this is filed. All these are filed on the 14th. You can see right up here. This is at 5:06 p.m. Okay. The judge is going to go nuts on this, you guys. So comes, okay. So this is a motion to suppress and memorandum in support, read Pennsylvania search warrant for the white Hyundai. In these, you guys, we get little tidbits of information, okay? Comes now, Bryan C. Kohberger, buying through his attorney, said blah, 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 blah. Filed a motion for an order suppressing all evidence gathered by law enforcement as a result of the entry into the search of Mr. Kohberger's vehicle. Issues. This court should apply Idaho's exclusionary rule and law to this search. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his vehicle without a valid warrant. The affidavit submitted in support of the application for the issue search warrant recklessly or intentionally omitted material information. They did have a warrant for everything, but she's saying because they used the IGG to find out who he was, that is reckless. It shouldn't have been allowed. So therefore, they wouldn't have the grounds to issue this warrant to search his car. Everything comes back to this IGG, and it's going to say it here. The affidavit submitted in support of the application for the issued search warrant. Okay, so there was a search warrant issued for his car, included information that must be excised. All information in the affidavit was gathered because of law enforcement's unconstitutional use of the IGG genetic genealogy, and thus nothing in the warrant should remain. Information about the client's locations taken from his phone must also be excised due to being gathered from an invalid warrant. So all of these warrants that were issued, she's saying are invalid because they should not have been able to use the IGG. Facts. Due to haphazard way in which law enforcement has kept and disclosed records in this matter, the following are facts as best the defense can tell. The following are the facts as best the defense can tell. Like, she's complaining she needs more time to go through all this discovery. Well, instead of doing all these frivolous motions and saying that their search warrants are null and valid because this whole case started because of IGG, the search warrants were issued properly. Once they add, hang on. Sorry, you guys, I got one hell of a cold again. So whenever I got a cough really bad, I'm going to mute myself. Anyway, just keep that in mind. Law enforcement got their search warrants and carried out those search warrants properly. So, but she's saying because of the way that they connected Bryan Kohberger, because when they arrested him and they did that buccal swab matched the DNA found on the knife sheath. Okay. And because of that, they can get all these warrants, but they're saying they never should have gotten the arrest warrant for Bryan Kohberger to begin with, because they used IGG to get to him. Okay. So it's already been ruled on that it was within the legal rights of law enforcement to use that. That was already decided by Judge John Judge. Why she's trying it again, I have no idea, but she is. Hello, Nikki Bobby. So it all goes back to this IGG. Once you are arrested, they have the right to take your DNA, especially for something like this. They got a court order to get his DNA, and they got court search warrants and everything else that they needed. They can search your house, your car, your apartment, your office. You are being arrested for 4 red drums, right? You got 4 first-degree red drums that you're being arrested for. They file warrants for your car, for your apartment, for your office, for your house, for your this, for your, they can, for everything. But they're saying he never should have been arrested to begin with because of the IGG. They went about finding out who he was by the IGG, which has already been ruled on. So, okay, so let's go over the facts. The following are the facts as best the defense can tell. On December 28th, Trooper Leary of the Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via Moscow Police Corporal Payne. December 29th, 4:44 p.m., a magistrate in Pennsylvania issued a search warrant for Mr. Kohberger's vehicle. On December 29th, the magistrate in this matter signed an arrest warrant for Mr. Kohberger in Latah County. The affidavit for the warrant was signed by Moscow Police Department Detective Payne. The basic facts Payne, how many pages is this? 9. The basic facts Payne used to support the search are described in a separately filed motion pursuant to Franks versus Delaware. We can't see that. They filed it under seal. The facts and issues are incorporated herein without repeating them. At 2:43 p.m. on December 29th, the criminal complaint and probable cause order were filed in this matter. At 10 p.m., 7 p.m. PDT time, Pacific time, Daylight time, Eastern time, 10 p.m., Pennsylvania SWAT began preparations to arrest Mr. Kohberger. Despite weeks of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. Eastern time. And despite the fact that weeks of constant FBI surveillance showed Mr. Kohberger was unarmed and tended to go for runs around his parents' neighborhood, police decided attacking Mr. Kohberger within his parents' home was the best option. Well, this right here isn't going to hold water because he was found to have guns in his possession. Oh, I better say pew pew, right? When you're going to arrest somebody who is being arrested for 4 first-degree red drums, right? He's dangerous. He just committed 4 first degrees. He's dangerous. She's saying, and despite the fact that weeks of constant FBI surveillance showed Mr. Kohberger was unarmed, which is not true. He had pew-pews and ammunition in his possession. Okay? They can't take a chance of knocking on the door, the guy opening the door and shooting at police, right? This is why when people are charged with these kind of charges, SWAT goes in. So she's complaining that she's saying that it was showed Mr. Kohberger was unarmed. That's a lie. He was armed. He may have not had it on his person, but he had it in his possession and tended to go for runs around his parents' neighborhood. Who knows if he didn't have that shoved down the front of his shirt? Police decided attacking instead of arresting. She uses the word attacking Mr. Kohberger within his parents' home was the best option. On December 30th, 2022 at 1:14 a.m., Pennsylvania SWAT and federal agents raided Mr. Kohberger's parents' home. During the raid, law enforcement found Mr. Kohberger's vehicle in the garage, seized, and later searched it. And that's what they should have done. They seized it, they got a search warrant, and then they searched it. This court should apply Idaho's exclusionary rule and law to this search. First, the first question this court must determine is whether there is a conflict of laws in this matter, whether Idaho law or Pennsylvania law controls the validity. Well, get it together. Get your tongue working right. Of the search warrant for Mr. Kohberger's automobile and the necessary relief. Well, it is the magistrate in Pennsylvania that signed that warrant because it was in Pennsylvania. Now, did Idaho want that car seized and searched? Yes, but Pennsylvania gave the warrant because it was in Pennsylvania. They were working together. That's how different states and law enforcement agencies work together. And then you've got the FBI who can do whatever they want across the U.S. Okay, they don't have to stick to one province. Willow, smarten up and get it together. You're not in Canada. Yes, I am. I am. You guys aren't. This isn't. So across the states, they can work in any state they want to work, right? So the issue, however, has received some attention in academia, which means there's been talk about it in the legal field, okay? Like with professors and lawmakers and stuff like that. Professor Kern argued in his article for the Harvard Law Review that the jurisdiction where the crime occurred should control how the investigation is done. And they are. But that state and or the federal government should provide some form of authorization to each other to participate in each other's criminal investigations. They did. They were working together. The FBI worked with them in Idaho. The FBI is working with the Pennsylvania police. Jeez. Fortunately for this court, Idaho and Pennsylvania do not differ in their approaches to the enforcement of their Fourth Amendment analog provisions. Both do not accept the good faith exception. Thus, and I'm not going to read all this crap, you guys. If you want to read it, you can. Thus, this court can likely afford to leave as an open question which forms exclusionary rules apply. However, it is also clear from the grounding of the exclusionary rule in Art 1, Section 17, that evidence obtained in violation of the Constitution must be excluded. She's talking about this IGG again, you guys. Thus, Mr. Kohberger argues that the Idaho Constitution exclusionary rule must apply as its basis lies not only in deterring police misconduct, but because exclusion is constitutionally mandated and judicial integrity demands it. Blah, I got that all out. Rose says, who knows, that Reed could have saved his family's lives, right? However, it remains to be determined whether the actions of the FBI and Pennsylvania state troopers should be viewed through the lens of Article 1, Section 17, or its analogs. It is not at all clear that whether a search should be judged by Idaho standards of reasonableness or that of Pennsylvania. It happened in Pennsylvania. That's the rules they used. He was arrested in Pennsylvania. They seized the car in Pennsylvania. They executed the search warrant in Pennsylvania. The FBI is there, which can work across both states. She's reaching, you guys. She's reaching. And she thinks the more that she throws in here is going to confuse somebody, but it's not. As noted, Professor Kerr would have Idaho's reasonableness apply in that the FBI and the Pennsylvania state troopers, oh, they got it right this time, troopers, were acting under its authorization, seeker, blah, 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 blah. It also goes along with the legal framework of agency. Restatement third of agency. Anyway, in this matter, Idaho authorities requested assistance from the FBI and the Pennsylvania State Police, as they should have. If you were an officer, say you're on a chase and you're on the highway and you're going from Idaho into Washington, you call Washington State Police ahead of time and say, look, we're on this chase. We're going to be entering your territory. If you have an investigation that is going to flow into the next state or any other state, whatever, you call them and say, look, we need your cooperation here. We've got somebody that is wanted or whatever, or we're investigating or surveilling. We need to come into your state. They work together. They did that. Okay. Thus, this court should be required to apply Idaho search and seizure law to their actions in Pennsylvania. No, that's not the way it works. If they are going to seize and search something in Pennsylvania, it falls under Pennsylvania law, not Idaho law, because it's not being done in Idaho. Even though it's the Idaho police that are the leads on this investigation, that's why you bring in other agencies if things are going on in their state so they can do what they need to do, governed by their laws of that state. I even know that. Come on. However, this concept has its detractors. McGlynn argues that when the status officer is performing the search, they should only be held to upholding their own laws. Well, that position has merit in it, as it does not require a situs officer to get a rundown of the differences between their law and the trial state's laws. It remains that the Idaho Constitution is not merely concerned with deterrence to officers who misbehave. They're following their way of doing things under their laws in the state that it's being done in. You can't expect a Pennsylvania cop to know the laws of Idaho. That's why they follow the rules and regulations and the laws of their own state. If it's being done in their state, it follows that state rules. Yes, the red drums happened in Idaho, but the car is not being seized in Idaho. It's being seized in Pennsylvania. Ugh. Ick. Achoo. Garbage. After all, if Idaho's law enforcement may take advantage of laxer restrictions in a different state, they may simply pause their investigation until their suspect is in that new jurisdiction. That's not what happened. So what she's saying here is they waited for Bryan Kohberger to flee Idaho or Pullman, Washington, so they could get him in Pennsylvania where their laws are laxer. That's not what happened. They had to get things done. They were waiting for the IGG and everything to come back. They were waiting for certain things to come back. They were surveilling Bryan Kohberger's parents' home. They were taking that trash, getting it tested to see if it matched Bryan Kohberger and what was on the knife sheet. They were doing all these things. Bryan Kohberger is the one who decided to take off from Washington. The cops weren't chasing him. He didn't even know that the cops had him in their sights. And if you go back to my December 9th reading that I did on this case, before any of us knew who Bryan Kohberger even was, I described who they had in their sights and described Bryan Kohberger to a T. Even that he did lectures and stuff for the college and universities. Go watch that read. It's under the live tab. December 9th. Scroll back. You'll find it. I described him before any of us knew who he even was. And I also said in that video that the cops had something. Well, that was the knife sheath. None of us knew that on December 6th. Anyway, go watch that. Okay, enough about that. So, they're trying to now make a statement saying that the police waited to arrest him until he was in Pennsylvania, who had laxer restrictions. That's not how it happened at all. They may simply pause their investigation until their suspect is in that new jurisdiction, or in the case of the FBI, state law enforcement could at any point, even within Idaho, call upon federal agents with the far laxer rules of the Fourth Amendment. So what is it, Anne? You can't have this all these different ways, because she basically is saying, she's trying to say, well, Pennsylvania has certain laws and they broke those laws. And then Idaho has certain laws and they broke those laws. But we like the law that they used here in Idaho, but we don't like this law that they used in Idaho. You can't have it. Oh, pick one. Pick one. If you're going to make this kind of argument, pick a state that you want to fight about. Anyway, finally, it must be said that there is very little daylight between the Idaho Constitution and the Pennsylvania Constitution. If anything, Pennsylvania appears to have stricter warrant requirements for particularity. Okay, so you're complaining about them using some of the Pennsylvania laws, even though their laws and Pennsylvania's Constitution has stricter warrant requirements. So which is it? You're complaining because these warrants were issued in Pennsylvania, but then you're saying, well, they appear to have stricter warrant requirements, which means they've got more rules they got to follow. So which is it? Do you want them to follow the rules, or do you just want where it benefits your client better? If the law in Idaho benefits your client better than the one in Pennsylvania, you want that search and seizure warrant to be issued per Idaho rules, even though it's in Pennsylvania? It doesn't make any sense. You know what I mean? You can't have it both ways, Anne. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his vehicle without a valid warrant. They had a warrant. Police cannot search a vehicle within the curtilage of a home without a warrant. Mr. Kohberger's vehicle was in his parents' garage in a home where he was an overnight guest. Overnight guests have an expectation of privacy in the home where they stay. Just 1 second, please. Can you Thank you. Sorry about that. Okay, where was I? Expectation of privacy in the home where they stay. Therefore, he had an expectation of privacy in the contents of his vehicle, and a warrant was required. Pennsylvania law enforcement search warrant lacked probable cause. The Fourth Amendment states ambiguously that no warrant shall issue but upon probable cause supported by an oath or affirmation of a particularly described the place to be searched and the persons or things to be seized. Probable cause exists given all the circumstances set forth in the affidavit. There is probability that contraband or evidence of a crime will be found in a particular place. They had his white car on video. They have him arrested for 4 first-degree red rums. That is more than enough probable cause that there could be evidence of that crime in his vehicle, since that vehicle they already had on surveillance around that house. And when you're arrested, everything is fair game. Your car, your motorcycle, your boat, your house, your cottage, your trailer, everything is fair game for warrants to search, to see if there's anything regarding the crime that you just been arrested for, if there is evidence in any of those places. So I don't know where she's going with this, but I mean, it's common knowledge. Thank you, K. Mitch. For a search warrant to be valued, here we go, Willow, get it together. The judge issuing the warrant must rely on an affidavit or affidavits sworn to before the judge or by testimony under oath and recorded that establish the grounds for issuing the warrant. Now, you know what she's going to go back to again? They arrested him and got a warrant on IGG, and we're fighting that. So everything should be thrown out. We're fighting it. They should never have used the IGG. We're fighting it, which was already squashed by the prior judge, but she's trying it again. You're going to see. Any discrepancy between the items for which there were probable cause and their description in the search warrant requires suppression. It is clear that the issuing magistrate himself, if he is to fulfill the constitutionality mandated function of interposing an independent intelligence between the law enforcement officer and the citizen, must actually and in fact draw the inferences from the evidence presented to him. It is for this reason that the courts have insisted that the full facts from which inferences must be drawn and information necessary to determine the reliability be placed before the issuing magistrate. Finally, the defendant may challenge the affidavit that was used, and that's what they're doing. Upon a preliminary showing of the warrant's deficiencies, the defendant must prove by a preponderance of the evidence that intentionalist or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately or recklessly omitted. And you know what they're using again? If you want to read through all this, you can. But they're saying that it was reckless, it was exculpatory facts that were omitted, stuff like this. But this is all regarding, again, all information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. This is going to be his argument for each and every one of these motions. She spews on about all kinds of other things that are, not constitutionally factual, things that people are being misled. There shouldn't have been search warrants. They were done illegally. Every argument that she makes for these warrants that she wants thrown out and suppressed, which means all this stuff she does not want used, is because they found out who Bryan Kohberger was by IGG. Investigative IGG. Okay? Investigative genetic genealogy. That is her argument for everything. They're saying that it was unconstitutional for them to even get a warrant for his arrest. And because that they feel that the warrant for his arrest was unconstitutional, that everything that they did after his arrest was searching him, his car, his phones, blah, blah, blah. All the warrants are unconstitutional and should be thrown out. Mr. Kohberger, in a separate motion, there we go. That's the first one I showed you. In a separate motion, that the genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he has argued there would be no investigations into him without that original constitutional violation. So, because of the IGG, they're saying that none of this is constitutional because they found him by IGG. It's not that the results of the IGG sped up the investigations. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows. Two identifications of little to no value, as previously argued. We're going to see this. As the Idaho Supreme Court has explained, while the initial burden is showing the factual nexus between the illegality of the evidence, the state must show that it would have been discovered anyway. The state cannot make this showing without IGG. There is no case, no request for his phone records, surveillance of his parents' home, no DNA taken from the garage out front, from the garbage out front. Because the IGG analyst is the origin of this matter, everything in the affidavit should be excised. Information about the client's locations taken from his phone must also be excised. See? She's putting certain things in here because she knows it's a problem. It's a big problem. Okay, and I'm going to say something, and I want you guys to comment on this. Everybody's saying, oh, the client, Bryan's locations doesn't prove he was at that house 12 times prior to the red drums. It doesn't. Like, 12 times he was in the area doesn't prove he was there. Okay? Now, listen to this. He was there quite often in a very short time, 12 times. Okay? Then the red drums happen. The next time he is in that area is for about 5 minutes the next morning. Like, I think he just went and drove by just to see if there was cops and everything there, and he seen nothing. So he took off back to Washington. Since the red drums, here we go, you guys. Since the red drums, he's never been back except for that very morning, once for 5 minutes. He's never been back. So he was still there until December, right? Like the middle of December, he left Washington and went back to Pennsylvania with his father, that drive that we all seen him get pulled over. The thing is, leading up to the red drums, he was there 12 times, very short times, like, how can I say this? Within weeks of these red drums, it's almost like he was stalking them. Okay? That's what it could be seen as. Around that 112 King Road house, 12 times before the red drums. After the red drums, he never goes back again. He's not a suspect, right? So people were arguing, well, oh, you're being biased, blah, blah, blah. He was going maybe to a bar or maybe to see another friend or going to buy drugs or whatever. Like, he was doing other things. He had other friends. No, we know he didn't have any friends because his father tried to get people to befriend him. Why didn't he go and see his friends ever again after the red drums? Why did he never go back to that area again after the red drums? If this was common for him to drive into Moscow, why did he never do it again after the red drums? Why? He had no reason to. Right? If he was going into Moscow because he liked this favorite restaurant or favorite grocery store or he had a friend there, why did he never, ever, ever go back again after the red drums? And yet before the red drums, every couple of days he was going around there. Something to think about. Okay? So, why is it that Anne is very concerned about, excuse me, her client's locations on his phone? Because the night of this, his phone is never seen out at this park gazing at the stars where he says he went. No, it's just south of Moscow. It's on its way towards Moscow. The phone gets shut off. And then the next time the phone is on, it's just south of Moscow, still in Idaho. Boise, near not Boise, Genesee. That's Idaho. So if he was stargazing in Washington, why was his car or his phone in Idaho just before the red drums and just after the red drums? If he was in Washington gazing at the stars, and that was like an hour and a half drive away. Doesn't make any sense. She's concerned about the location data because it's going to put him there. Separately, the information gathered via the warrant for Mr. Kohberger's AT&T account and the pen trap and trace device warrant should be excised for the reasons set out in those warrants. So they traced his some device. They put a pen trap and a trace device. Right? Conclusion. Mr. Kohberger requested this court suppress all evidence obtained by police via the warrant that permitted them to search his car. As explained above, this warrant lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions, which means they didn't tell the magistrate that they finally found their suspect, their guy, by IGG. But she's making this out to sound like they totally lied in this affidavit. Okay? And because the warrant omitted exculpatory information and information that put into question the reliability of facts upon which it relies, and finally, because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment. Right? All right. Okay. Search warrant for the defendant's apartment. This is 12 pages, so we're going to be skipping a lot. Again, her argument on this is going to be that they never should have, the warrant is unconstitutional, should never have happened because he was arrested because of IGG. Never should have been arrested. Even though now they got a buccal swab from his mouth, and that DNA from his mouth matches the DNA found on the knife sheath, they still say he should never have been arrested. His car is caught on video, and it will come out in these documents. She says it, that car with no front license plate, Idaho and Washington both require your car to have front license plates. Pennsylvania does not. His car was registered at the time of the red rums. His car was still registered in Pennsylvania. The red rums happened on the 13th. He changed his plates to Washington plates on the 18th. Why would he do that if he was going back to Pennsylvania anyway? Why wouldn't he have just left his Pennsylvania plates on? Something else to think about. He was leaving. He was going back to Pennsylvania. Why would he have not left his Pennsylvania plates on? Why, after the red rooms, did he decide, oh, I got to change my license plates now in case I'm caught on camera? I got 2 license plates. Because he knows the police, if they're looking for, when the information about the car came out, that they have this car on video that was around that place and doing what it was doing, the car had no front license plate. Oh boy, I better go, so I don't get stopped or looked at. I'm going to go and register my car and get a front license plate and register it to Washington. And that's exactly what he did. 5 days after the red drums. IGG is investigative genetic genealogy. So everything comes down to the police should never have been able to use the IGG, which got the name of his father, which led them to Bryan Kohberger. The IGG testing came back, the DNA from that sheath came back, that it will match one of Michael Kohberger's male children. He only had one male child, and that was Bryan. That's how they got Bryan, okay? But prior to that, they'd already had this vehicle. So he's getting spazzed out. Oh my God, I got to go and change my license plates. And that's what he did. And why would you do that if it wasn't you that did it? You had nothing to hide. Why would you do that? Especially when you're taking that car back to Pennsylvania, where now you have to register it again in Pennsylvania and change the plates back to Pennsylvania. It doesn't make any sense, right? You're welcome, K. Mitch. So, motion to suppress memorandum in support, search warrant for the defendant's apartment. Now, we're going to go through these, you guys, quickly. I'm going to skip a bunch of things, but there is information that comes out that we didn't know. Wait till we get to the search of his parents' place. Wait till you hear that one. It's next. What they did. Ooh. Boy. Comes now. Okay. The following motion and memorandum in support of the order suppressing all evidence gathered by law enforcement as a result of the search of his apartment. Well, if they didn't find anything in his apartment, don't forget they found that animal hair. Ding, 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 ding. If that animal hair comes back to Kaylee's dog, oopsie. Why does she want anything they found in his apartment thrown out? Well, There's receipts for a Dickie onesie that was never found. Where is it? You just bought it just before the red rooms. It was kind of expensive. Where is it? They found a receipt for what was it, for the onesie, for a few things, I think. I forget now, but you guys, I know you guys are smart. You'll remember. They found receipts. They also found something from Amazon regarding a K-bar knife and sheath purchase from Amazon. Oopsie. Which are nowhere to be found. Okay, Bryan. They're saying that there was a K-bar knife used, and that K-bar knife sheath was found under Madison. Bryan, you bought one just a couple months before the red drums. You bought a knife and a knife sheath, a K-bar, from Amazon. Where is it? They have not found the onesie. Why? They have not found the K-bar knife. They got the sheath. Okay, Mr. Kohberger, where, if you're saying this isn't you, please produce the K-bar knife and sheath that you just purchased a couple months ago. Where is it? Please produce the Dickies that you just bought. What was it, a couple weeks before the red drums? Please produce the balaclava that you purchased. Where is this stuff? He can't produce it. It's gone. Poof. Somebody broke in and the only thing they stole was this balaclava. They stole his Dickies mechanics one suit. It's pretty much like that what you call it. You see the mechanics wearing those onesies. And a K-bar knife and sheath. That's the only thing they stole out of your apartment, Bryan? Where are they? Where are those things you just purchased before the red drums? Right? Something to think about. Why can't he produce that? Now, don't forget, they found the receipts for certain things, which I can see why Ann Taylor doesn't want those coming into evidence. But they also, to me, the biggest thing is that animal hair. Was that animal hair from Kaylee's dog? Can you imagine? Right, Isabel? How convenient that. Where's this stuff that he purchased? You just purchased this stuff, Bryan. Where is it? Produce it. It's nowhere to be found. And it's funny that that's what the person who did this crime, they were wearing like a mask thing. Like, I believe it's one of those hats that you can for winter that just, leaves your eyes open. Where is it? Where's your Dickies? Where's the knife and the sheath? You can blow us all away by producing that. Where is it? Gone. And it's funny that that's exactly what the person who did this crime used. You purchased this stuff and it's gone. You can't produce it. No, because you've had to get rid of it to hide your crime. And it's going to be argued. You watch, you guys, come trial. Mark my words. Timestamp this. Mark my words. They're going to use that. And heaven forbid if that animal hair is from Kaylee's dog. The motion and documents in support of Franks versus Delaware. That's where they're going to say that the police unlawfully used IGG. The police did all kinds of things that they shouldn't have been doing. That's what she's saying. Hearing they are incorporated into this memorandum. The proffer with supportive documentation regarding Franks are filed under seal. That's the very first document that we read. And they're saying that the use of the IGG to get to Bryan was highly illegal. Therefore, his arrest should never have happened. It was unconstitutional. And it's going to be like that for each and every one of these motions. But there's some of these motions I want to read because we get some information, especially in the next one. The court should apply Idaho's exclusionary rule and law to this search. Okay, but no, because this search of his apartment was done in Washington. So it would have to fall under the rules of Washington. Even though Idaho is asking Washington state troopers or whatever to do it, they have to follow their rules in their states because that's where the apartment is. That's why the FBI is involved, because it's across state lines. Things have been happening going back and forth across state lines. He has. They have to follow the rules of Washington to search his place in Washington. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. And what they're saying, the omitted material information, even though it's under seal, we know because of the Franks motion that was filed, is that they're trying to say that he was arrested illegally and unconstitutionally because they used IGG. The affidavit submitted in support of the application for the search issue warrant included information that must be excised. All information in the affidavit was gathered because of law enforcement's unconstitutional use of, there it is, of IGG, and thus nothing in the warrant should remain. Information about the client's locations taken from his phone must also be excised due to being gathered from an invalid warrant. So they're saying the warrant is invalid because they got to Bryan Kohberger by IGG. Okay, and then they go over, they basically say the same thing again. Okay? They say, give these same dates and everything again. But I will scroll through this so you can, all through 12 pages, so you can read it if you want to. This next part, page 3, we are going to be reading. On December 29, 2022 at 2:22 p.m., the magistrate in this matter, get rid of this, signed an arrest warrant for Mr. Kohberger in Latah County. The affidavit for the warrant was signed by Moscow Police Department Corporal Brett Payne. The basic facts Payne used to support the search were: next to the body of Madison Mogan was a tan leather knife sheath. The Idaho State Lab later located a single source of male DNA on the button snap of the knife sheath. Now, we don't know what single source of male DNA this is, right? Is this blood? Is it skin cells? Is it sweat? Is it spit? Is it saliva? We don't know what kind. It's just saying that it's a single source from one person, not multiple, a single source of male DNA. The footage from the King Road neighborhood showed what police suspected was the vehicle of the bingo. This white sedan lacked a front license plate. Bingo. Both Idaho and Washington require front and back license plates. Pennsylvania does not require that. They only require a back plate, which was what was on Bryan Kohberger's car the night that this happened. Okay? The vehicle specialist decided, based on the footage, that the vehicle was a 2011 to 2016 Hyundai Elantra. A vehicle matching that description was spotted via surveillance in Pullman. Okay? So, that night, I know I got information from different sources regarding this, that there's surveillance cameras that caught him leaving and coming back, which way he left and which way he came back. There's cell phone GPS tracking and that they filled in the blanks with, and other cameras in Moscow. None of those cameras show him going to the left and going way over to this park. So they're trying to get all of this thrown out. It was later discovered that Mr. Kohberger drives a 2015 Hyundai Elantra and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. That same specialist indicated the car seen in Pullman was a 2014 to 2016 Hyundai Elantra. Witness Dylan Morrison had indicated the height of the person she saw at the time of the attack was between 5'10" and 6 foot, and they had bushy eyebrows. Police determined Mr. Kohberger fit that description. Records from an August 21 traffic stop in 2022 stop showed Mr. Kohberger was the driver of a white 215 Hyundai Elantra with Pennsylvania plates lacking a front plate. Exactly what was happening on this. If you think they've only got 1 or 2 surveillance videos from around 1122 King Road, you're wrong. They've got lots. Okay? So, he didn't have a front license plate when he was stopped in August of 2021 either. It was a Pennsylvania plate. It also showed he had the phone number. Okay? So, when they got this IGG information back, remember I told you it's going to come out after down the line. I'll show you. So people can't say, Willie, you didn't show us that. Yes, I did. Here it is. So records from these traffic stops, right, show, okay, this is, so I'm going to bring you up to date. They find DNA on the snap of the sheath. They run it through CODIS. They find no hits. So they run it through the IGG database. Okay. They get a match to Michael Kohberger. They say in that match that the DNA found on the sheath is going to be an offspring, a male child of Michael Kohberger's. So they look up Michael Kohberger in Pennsylvania and they find out he only has one son. His name is Bryan Kohberger. They then run Bryan Kohberger through the system and they find out he was stopped in Idaho on August 21st, 2022. And on that stop, he has a 2015 Hyundai Elantra with Pennsylvania plates lacking a front plate. Ding, ding. They got video cameras showing a white Hyundai with no front license plate circling around the crime scene that night and then taking off and never seen again. So then they started getting all the GPS that they could for this car. And they also had a number for him because of this traffic stop, a phone number. So then they started investigating the phone number. That's what investigations do, right? Okay, Nana, you take care, hon. Okay, so he gave this phone number. This information was taken because of the traffic stop in August of 2022. And he also gave his phone number. He noted investigators learned this was an AT&T number. Mr. Kohberger had changed his vehicle registration to Washington plates on November 18th. Once the police said they were looking for this 215 Hyundai Elantra, he went and changed his plates 5 days later. Right? It's like, oh my God, they have my vehicle on CCTV somewhere. Oh my God, they're going to see I only have one plate. I better go and get Washington plates put on so I've got a front and back plate. And they're going to say, oh, no, it's not that car because that one has a front and back plate. Right? I worked in criminal law too, Mr. Kohberger. So I know what you're thinking here. Cell tower records did not show Mr. Kohberger was in Moscow at the time of the red drums. No, because on his way from Pullman, crosses into Idaho, he turns off his phone. But he's caught on several CCTV footages along that stretch of highway. His car is caught. In law enforcement's experience, however, people committing crimes typically turn off their phones. So you're admitting that. Historical cell site locations information was obtained and given to cellular analysts CAST with the FBI. The team determined that on November 13th, at approximately 2:42 a.m., Mr. Kohberger's phone was utilizing cellular services that provide coverage to his apartment in Pullman, Washington. Jeff H says that it's hard to tell if he renewed with Washington plates because they were about to expire, but he was going back to Washington, right? back to Pennsylvania. So I haven't heard that his plates were about to expire, but that, Jeff. So thank you for that. Oh my gosh, my screens just went blank. Can you guys hear me? Can you guys hear me? Let me just check over here. Can you guys? Yes? Okay, because both my screens went blank for some reason. Black. So I don't know if you guys seen that. Did you see the screens go black? Did my screens go black, or did this constantly stay on the screen? Because my two screens in front of me went black. That's twice that it's done that, and I don't know why it's doing it. I think it's because I got so many things open. Yes, feel better, Nana. Oh, you did see it go black? Yeah, they went black, and it's like, what the hell? I don't know what happened there. I think it's because I got so many windows open, you guys, on 3 different screens here. Okay, but it's back now? Okay. Oh, because I didn't move my mouse or keyboard? That could be. That could be. Thank you for that, Jeff. I'm going to have to look at check. Sleep. Because I know I did an update, and ever since the update, it's been doing that. So it could be I have to change that my computer doesn't go to sleep if I haven't touched the keyboard in a bit. Okay. Thank you for that, Jeff. I will definitely check that out once I'm done. Okay. So, where was I when this went black? Okay, here we go. The cast. Yeah, I hate the updates too, Carol. That team determined that on November 13th at approximately 2:42 a.m., Mr. Kohberger's phone was utilizing cellular resources that provide coverage to his apartment in Pullman. They support the idea that he left his apartment and went south. They supported the phone being off. They support at 8:48. Okay, so this is all that it's showing. The analyst, the cellular analyst, is showing. It supports that at 4:48 a.m. the phone is in south of Moscow, Idaho, near Blaine, Idaho. So if your client went in Washington to this park that's like an hour away in Washington, how could he be over here? Look at this. 20 minutes from the time that he left to where his phone started pinging, he turned his phone back on, is about 20 minutes when he leaves the area of 1122 King Road. He had to dispose of everything. It takes 15 minutes to get to where he was when his phone was turned back on. So 15 minutes, and there's 28 minutes here. He had some time to dispose of the clothing and the weapon. That's why I think he went back the next morning to see if, I don't know, maybe he could sneak in and see if he dropped the sheath somewhere around there. I don't know. The phone utilizes resources that make their way back to Pullman, coinciding with a white Hyundai Elantra seen on some surveillance there. They've got him on surveillance, you guys. Okay? Yeah, I don't even want to try to bring up the map, K-Mitch, because my computer's already, I think, overloaded. But we can do that at the end of this. A similar data showing occurs at approximately 9 a.m. with a trip into Moscow and returning at 9:32. That same team determined that Mr. Kohberger had been to Moscow on at least 12 occasions prior to the event, and that he came into the area the morning following the murders. However, law enforcement without explanation indicated it did not believe that final trip ever occurred. Now, 12 times just before the red drums. But then never again does he ever go back. That's not somebody that goes to Moscow often for dinner, for a favorite restaurant, to go see a friend, for this, for that. Because once this crime happened, he never went back again. And I think that's going to be used, you guys. So at 2:43 p.m. on December 29th, the criminal complaint and probable cause order was filed in this matter. At 10 a.m. Oh, so it goes down into SWAT began preparations to arrest Mr. Kohberger despite days of constant FBI surveillance. Now they're saying days. In the other motion, they said weeks of surveillance on him. No, it was days because it took them time to get that IgG information back. And they're saying here, despite days of constant FBI surveillance, the other motion she filed, it said weeks. Like, figure it out, Anne. Stop it. Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. What? Despite days of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. Okay. And despite the fact that constant FBI surveillance showed Mr. Kohberger was unarmed and tended to go for runs around his parents' neighborhood, police decided that in the dead of night, and here we go again, they didn't know if he was armed or not because weapons were found. He had possession of weapons. And you're going to arrest somebody who's been accused of taking the life of 4 people. They're going in with SWAT and fully armed, and there's not... Hello, it's the police out here. We need to talk to you. Like, can you come? You want to come? Come on. Merry Christmas. You want to come out and talk to us for a bit? Maybe sing a jolly old tune? No, they're booting down the door and they're going in with SWAT. This guy has been accused of just red drumming 4 college students. You think they're going to go in and bring maybe a coffee and donuts with them? No. Right? And they didn't know if he was going to be armed. They knew he had weapons. He goes for runs around his parents' house. You don't know if he's got a weapon on him. Police decided that in the dead of night are within his parents. Like, this makes no sense. Police decided that in the dead of night are within, just like this letter R, within his parents' home, are within his parents' home was the way to make their, whoever typed this up. Anyway, but they're whining and crying again about how he was arrested. He's been accused of just taking the life of 4 college students brutally. You want him to go in with what? Kid gloves and some coffee and donuts and let's sit down and have a chit chat? No. Who's to say he wouldn't have opened fire? They knew he had registered weapons. Okay, so I found the frame where you can see the female holding up Bryan's PA car registration. It shows it expires 11/30th. I can send you some still frames. That's okay. I take your word for it. I do believe, Jeff, I might have heard something like that before, but I'm not sure. But if you say you can see it, I trust you. I trust you, Jeff. So thank you for that. Jeff says it looks like he even handed the officer a copy of the previous year's registration too that has expiry of 11/30/21. Okay. Thank you for that. Okay. But he was still going back to Pennsylvania with that car, right? So I don't know. Like, why would you change it to Washington? I would have just driven on expired plates, got back to Pennsylvania and renewed them. But they could have renewed them in Pennsylvania for him, right? Okay, so where are we? Okay, at 9:25 p.m. on December 29th, the Superior Court judge in Washington issued a warrant for Mr. Kohberger's apartment in Pullman. That warrant was based on the affidavit of Assistant Chief Don Daniels of the WSU Police Department. Okay, so a Superior Court judge in Washington issued a warrant for Mr. Kohberger's apartment. Yes, I'm sure Idaho cops, who are the lead in the case because it happened in Idaho, had to get a Washington judge to give the warrant for his apartment because his apartment was in Washington. And it makes sense. Right? The warrant was based on the affidavit of Assistant Chief Don Daniels of the Washington State University Police. That affidavit shows that Sergeant Blaker of the Moscow Police Department requested the assistance of the WSU Police Department in investigating the case. The affidavit relied on the same information outlined above. There was also, wait a minute, there was also security from Washington State University that said, hey, this guy is really weird and he has a Hyundai with no front license plate. You guys need to come and check this out. That was in the documents too. There is somebody from the University of Washington. It was a security or Washington State University coppers. I don't know if they're just called security or if they're actually sworn in police officers that patrol Washington State University. I don't know. It's totally different between US and Canada. But somebody that takes care of security at Washington State University reported Bryan Kohberger as somebody they need to look into, that he was really weird and stuff like that. If I remember correctly, you guys, in investigating the case, the affidavit relied on the same information outlined above. They're saying that it only relied on the IG because of the IGG. They're going to use it again. And like I said, every one of these warrants that was taken out, they're going to say excised because he shouldn't have been arrested in the first place because they used the IGG, which they shouldn't have, which is bullcrap. A lot of police departments use the IGG. Anyway, on December 30th at 1:14 a.m., here we go. Pennsylvania SWAT and federal agents raided Mr. Kohberger's parents' home. Law enforcement arrested Mr. Kohberger. On December 30th, Idaho State Police and other law enforcement searched Mr. Kohberger's apartment. So Idaho can go and be part of that search. Idaho cops can be there and be part of that search as long as they have the okay from Washington cops. That's how they work together. But they have to follow Washington's laws because they are in Washington. That apartment is in Washington. So the Washington cops have to be there too to make sure they follow the rules of Washington with search and seizures. So she's saying again that the court should apply Idaho's exclusionary rule and law to this search. Okay? They're going to do it again. And they're going to blame it on the IGG. That's why I'm scrolling through this. This is all the same that we've already read in the other motions. See? It is not all clear whether a search should be judged by Idaho standards of reasonableness or that of Washington, or in the case of the FBI, by the Fourth Amendment. That's what they're trying to fight. If they are doing it, if the apartment is in Washington, it follows Washington's standards. If it's in Idaho, it follows Idaho standards. That's just the way it goes. So like I said, I'm going to scroll down this. That's what they're fighting, that which law should we go by, where the crime took place, or by Washington's. It depends. the crime, the laws surrounding the crime itself is Idaho. His apartment is in Washington. If they want to search it and see stuff, they have to follow the Washington's laws of that state for search and seizure. But the case itself, the red drum, follows Idaho law. Oh my God, I don't know why she has to make this so complicated. And she, like I said, just trying to bury them in paperwork, okay? Same as in Pennsylvania. If they search his parents' home in Pennsylvania, it's got to follow the rules of search and seizure in Pennsylvania. They have to have Pennsylvania cops there if Idaho wants to be there too. As long as Pennsylvania cops say, yes, you can be here, but you got to follow our rules. Everything's got to be done by the book, by our rules, and we have to be there to make sure that's done. Then it's okay. It can be used. Again, here we go. All information in the affidavit for this search and seizure of its search of his apartment. All information in the affidavit was gathered because of the law's enforcement unconstitutional using the IGG, and thus nothing in the warrant should remain. And it's like this through every motion. But in some of these motions, we get some little tidbits of things that we haven't heard before. Okay? Information about the client's locations taken from other illegal searches must also be excised due to being gathered from invalid warrants. So, from his phone, because there's lots of information I'm sure that they've gathered on that phone. And don't forget, once everything went under seal and a gag order put on this case, we're not going to hear what else they found on his phone. They probably got the main parts were his whereabouts and stuff like that from the phone. But his search results, what he searched for, does that phone show him investigating Kaylee or Zaina or Maddie? You know what I mean? Does it show, is there information on that phone that showed him going on to Maddie or one of the other Kaylee or whatever on and checking out their Instagram and sending them pictures? You know what I mean? It holds a lot. We're not going to hear about all that if that's there. The defense isn't going to bring it out because it's all under gag. It'll be all, if they talk about stuff like that, it's all going to be under seal and we're not going to know about it. And just because Ann Taylor says, well, they've really got nothing that ties my client. She can say that all she wants. It doesn't mean that it's true. Because right now she's saying that none of this can be used. All this is garbage because they arrested him based on IGG. Even though his buccal swab that they did is a perfect match to the DNA found on the knife sheath, she's still going to say none of this matters. None of this matters. So by her saying they've got nothing, say they've got pictures, and this is just hypothetical. Say she's got, they found pictures, and this is hypothetical. This has not happened, you guys. Please listen to me. This has not happened, but I'm trying to set up a scenario here. Say once they really dived into his phone, they found photos of him taking pictures of Kaylee and Maddie through the bedroom window. Say they found that. She can still say they've got nothing linking Bryan Kohberger, even though they've got those pictures, which they don't have. This is a hypothetical, you guys. She would say they've got nothing because in her mind, they can't use that because they illegally searched his phone because they illegally arrested him using IGG. You see how that happens? So she's not actually lying because in her mind, anything that they have searched, seized, looked at, whatever, with all these warrants, they're all illegal and have to be excised because he never should have been arrested to begin with because he was arrested based on IGG. But they did go through that garbage and they did get his DNA and matched that DNA too before even the buccal swab that they got from him. They matched that DNA to the knife sheath. Then when they did finally arrest him and took the buccal swab, 100% matched. But in her mind, all she sees is, you guys got your first lead because of the IgG testing, so nothing that you've gotten matters. Even if you got somebody who took pictures of him doing the act, they don't count. He didn't do it, because none of that should be admitted, because he never should have been arrested. Right? Right? So if they have, say they have pictures that somebody took of him doing that with the to each of them. Oh, you can't use them because he never should have been arrested in the first place, because you used IgG to get to him. You found his father through IgG. That's how you found out that it was Michael Kohberger's male offspring that left that DNA on that knife sheath. And because you used that way to find my client, everything is to be thrown out. It's illegal. It's not. Well, Anne's very afraid. Anne's very afraid because she knows that he's going to be found guilty, I think. In my opinion only, don't sue me. My opinion only. So like I said, hypothetically, even if say the prosecution had photos of that somebody took of him doing that act, each one of them, she's saying, nope, you can't use them because he never should have been arrested to begin with. You know what I mean? That's what I'm trying to say here. That's what she's doing with each and every one of these warrants. Wait till you see how they entered his house. Parents' house. We're getting to that one right after this. We're done this one, basically. Mr. Kohberger requests this court suppress all evidence obtained by police via the warrant that permitted them to search his apartment. As explained, the above warrant lacked probable cause because, as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to deal its own conclusions, and because the warrant omitted exculpatory information, they're saying this is all about the IgG. Okay? So let's go to the next one. Here we go. This is going to be the good one, you guys. Let me just check chat here for a minute. Right? Yep. So, like I said, you guys, they could have found so much more stuff on his phone. We were not going to know until trial because everything is under seal and there's a gag order. So for all these people that say, you know what, they only got that one video, they only got the DNA that was on the knife sheath, and they have got tons more. We don't know about it, you guys, because it's under seal and there's a gag order. And Ann Taylor's standing up in court saying, they've got nothing. She's saying that because she's saying he never should have been arrested to begin with because of the IgG that led them to him. So none of this, even though it shows he's probably the guy, doesn't matter. You can't use it because he never should have been arrested because you used IgG to arrest him, to get an arrest. Well, it was more than just the IgG, because then they surveillanced him. They got the garbage that he threw out, and they tested that against the DNA on the knife sheet and found they matched, and his buccal swab after arrest also matched. So, but she's saying that they never would have been led to Bryan Kohberger had it not be for the IgG, which she says they're not allowed to use. So, and all of this and all their investigation is null and void. Even if they have proof of Bryan Kohberger being in that house, if there is proof of that. You know what I mean? She's saying, too bad. I don't care if somebody videotaped them doing these crimes. You never would have been led to my client if it wasn't for the IgG, so you can't use any of this, including the video that somebody took of my client doing it. You know what I mean? And that's a hypothetical. There's no video. I'm just saying, if there was, my client didn't do it. And you can't use any of this because he was arrested illegally. Anyway. Jeff says, so many trust every word Anne says. Anne can get up and say, it's not true. They've got nothing, because in her mind, all this is going to be thrown out. Right? But she is doing her job. Question, did they obtain the DNA illegally? No. Many law enforcement agencies have used the IgG and it has stuck in court. When challenged, it has stuck. Marty Booten says, keep it pure factual. That's what I am doing. I was giving a hypothetical to explain why Anne can say, even if you have this, it's not admissible because you arrested him on illegally using IgG or unconstitutionally using IgG. I was trying to give a scenario so I could explain what I was trying to say because I didn't have the right words. And I did say, this is not facts. This is hypothetical, so you understand what I'm trying to say. Yes, technically she's grasping at straws. Everybody knows here I keep it factual. Anything on Jack Showalter? He was arrested and was in the sin. Jack has nothing to do with this. Jack is not part of this. Jack has been cleared. Rose says, I missed your accent, beautiful Willow. You're nailing this to the wall. My accent? I have an accent? Seriously? I don't find I have an accident. An accident. An accent. But I like the Southerners from the Southern states. I went down there once and it's like, oh my God, I love you guys' accent. And it's like, oh my God, are you Canadian? And it's like, yeah, how'd you know? Your accent. What accent? So they didn't feel they had an accent and I didn't feel I had an accent. So it was cute. But there's a lot of places in the U.S. I love their accents. So, but thank you for that, Rose. I appreciate you. Midnight Baker says, great show, Willow. Thank you for reviewing this. It's more informative and enjoyable with your expert commentary. Well, thank you. Thank you. I try. My mouth sometimes isn't working right, so I got to give myself a little bit of shit there. Like, get together with this, Willow. Pay attention. It's because I try to read it too fast, and my mouth isn't keeping up with what my brain is processing. So, but thank you for that. I appreciate you. Canadian accent, Carol says. Okay. I get it because a lot of people that I've met, even Jersey and stuff like that, it's like, we have an accent? Yeah, you do. Like Boston, the Boston accent. I love it. Anyway, let's get back to this, you guys. But thank you for your comments and I appreciate them. Love the way you think out loud. Oh, I have arguments with myself all the time. It's like, Willow, smarten up. I'm trying. Try harder, Willow. Okay, I will. Here we go. Okay. I love this one. I think there's a couple of other ones. I'll just briefly show you because I don't want to keep you guys here any longer than necessary, but these are the main ones. I'm going to show you briefly the other ones, but okay, let's go. Willow, stop babbling. Okay. Pennsylvania search warrant for 119 Lambston Drive, Albrightsville, PA, and statements made. You bet your booty. You bet your booty. He made statements. He made some statements. Now, we know he made one statement. Well, was there somebody else arrested? Right? We know he made that statement, but apparently he made quite a few statements. So, let's get into this one. Bryan was set up and framed from day one. Whoops, where's my thing? Okay, Mitch says, you're a joy to listen to, Will. Thank you. Kazzy Kaz, welcome to the channel. I haven't seen you here before. Says, Bryan was set up and framed from day one. Okay. It's a difference of opinion, but that's okay. You're entitled to your opinion here. Do you think anything will come of the Frank's motion? No. No, I don't. I do believe, if you guys remember way back, there was something with one of the officers and she wanted their training history and all this garbage. Right? So Nothing ever came of that. It was brought up a couple times in hearings that we did get to see, but it went nowhere. But the Frank's motion, she is just basically saying that they arrested him illegally. So every search, every seizure, every warrant that was issued was unconstitutional or illegal because they were going by, they found him using IgG, and that they never would have found him any other way if it hadn't have been for that IgG. So what they want is they want the cops to prove that they would have found out all this information regarding Bryan, regardless of the IgG. Right? Well, I don't know. I don't know how the judge is going to rule in this. This is already ruled on by Judge John Judge, and it was admitted into the record and into court. So she's beating a dead horse with this because she's still saying that it was totally illegal for them to use the IgG. So Nikki says the right guy is in custody, in my opinion. Nikki thinks they do got him. So some differences of opinion in here, and that is okay. So please do not attack each other for differences of opinion. You guys can each have your own opinion. Here you are entitled to your own opinion without being attacked for it. As long as you're not attacking anybody else or, trying to pick a fight or something like that, you're entitled to, have your own opinion on it. So, but let's just do it respectfully. We got a difference of opinion in the chat, and that is cool. I love a good debate. Kazikaz says they need to investigate LE and school officials. Too many suspicious deaths written off in Moscow. Ooh, interesting. That is very interesting, Kazikaz. So thank you for that. Okay, so let's get to them. Yeah. Arresting him at his parents' house. What happened there? Here we go. Comes now. Bryan C. Kohberger, by through his attorneys of records, and submits the following memorandum. How many pages is this? 18. We are not reading all 18 pages. I will skim through it. I will give you the facts that she puts in, her arguments, and her conclusion. All the cases that she cites and all that in between. I will scroll slowly. So if you guys do want to go back and read it all later, you can. So let's hit on the main points here. Grammy says, Willow, have you done a reading on Showalter? No, I refuse to do that because he's not involved. He's been cleared. Cassie Cass says, check out, if you hear clicking, sorry, you guys, that is my coffee mug. Check out the deaths in the last few years. I'm going to do that, Cassie Cass. Actually, I'm going to write it down right now. And is that in Moscow itself, Kazikaz? Is that in Moscow itself, or is that like a wider area around maybe Moscow, or is that just in Moscow? Let me know that, because I am definitely going to go and check that out. And that may be why you feel he may have been framed. Right? Oh, absolutely. You're entitled to your opinion, hon. Okay, just in Moscow. Ooh, that's interesting. I am going to look into that, Kezi. Okay, so let's get back to this. A motion filed in order for expressing all evidence gathered by law enforcement as a result of the entry into search of Mr. Kohberger's parents' home at 1119 Lambsden Drive, Albertsville, PA, including statements made after his arrest. The motion and documents in support of Frank's. See, this is it again. The Frank's motion is all going to be regarding this IgG. They want it thrown out. If you throw out the IgG, how they got to Michael, which then led to Bryan. If they get that Frank's motion approved, then they can get all this thrown out. Because if they feel within that Frank's motion that law enforcement did something wrong and misused IgG or something along them lines, then the arrest would be unconstitutional. But this has already been argued, and it was allowed, and it was decided upon by a previous judge. So I don't know why she's doing this now. I was going to ask who Frank was. Kezzy says suspicious deaths linked to schools. Ooh, can you email me that, Kezzy Kaz? Here, I'll put my email. Whoops. Whoops. Okay, so there is my email, Kezzy. If you can email me that, I would be forever grateful. And I will. I promise you, I will. I will look into it. And here is my email right there. Just, it doesn't have readings on it. It's just above and beyond ancestor at outlook.com. Okay, so let's get back to this. So here we go with the Frank's motion again. Carol was going to say, who's Frank? They're incorporated into this memorandum. The proffer with supportive documentations regarding Franks are filed under seal. So here we go. Here are her issues. I'm going to read through her issues, but we're not going to read through every case that she cites and all that. It's just too time consuming. Thank you, Kezzy. I appreciate that. Okay, so these are the issues that Ann Taylor has. This court should apply Idaho's exclusionary rule and law to this search. Mr. Kohberger has standing to challenge the search of his parents' home. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his parents' home without a valid local warrant. We read that the magistrate in Pennsylvania issued the warrant. Idaho called Pennsylvania, or you got the message of Pennsylvania. We need a warrant to get in that house, right? The Idaho arrest warrant could not have given police in Pennsylvania the authority to enter the home. I do believe now, as somebody who is, don't forget, I'm in Canada. In Canada, if there is a warrant out for your arrest, especially for 4 redrums, they can boot in anybody's door if they know that you are in there. They can boot in your door. So the Idaho arrest warrant, so say you have a warrant in British Columbia, Canada, for this exact thing that Bryan Kohberger is being charged with, and police get wind that you are staying at my house, right? BC is going to call up Ontario Provincial Police or the RCMP and say, we've located this person and they are in Willow's house. Go get them. That warrant is wherever your body is. If you run into a restaurant and lock the door, they're booting the door. Because the warrant, now I don't know if it's the same in the States, but here in Canada, that warrant is for the person no matter where they are. Now, if they want to come in and search my place, they can boot in my door and grab him and take him out. Now, if they want to come in and search my place, they have to get a warrant, right? But they have a warrant to seize the person. And if that person is proved to be in my home, they can boot in my door. They can't search my house without a warrant, which they did get a warrant in Pennsylvania to search his parents' home. They don't need a warrant to enter the house to grab him. They already have a warrant for his arrest no matter where he is. It's just Idaho can't go into Pennsylvania and go and arrest him. They have to have Pennsylvania police or FBI do it. So, they've been following the book as far as I've seen. Yes. Jeff says, I love how adult-like you are to allow other opinions on this Idaho case. Wish all others could manage that. It seems they prefer to make it like a middle school playground. Yes, like I've told everybody, I 90% think that he did it. I think they got the right person. I'm leaving that 10% because what if Ann Taylor has something and says, boom. You know what I mean? But I'm not 100% there, but I'm 90. I'm leaving that 10%. Although the defense doesn't have to prove anything, with what I know so far, I'm saying 90% they got the right guy. Yes, we are very humble here. Safe place for everybody. And I'm not going to let anybody here attack other people either for, like Kezi. Kezi has a different opinion. That's okay. Maybe Kezi is like 90% he didn't do it, 10% maybe he did. So Kezi could be the exact opposite of me. 90% I think Bryan Kohberger is innocent, 10% I think he did it. Whereas I'm 90% I think he did it, but I'm leaving that 10% there for something to come out in this trial that goes, oh geez, maybe he's not. You know what I mean? So, and I don't want anybody, no matter what your opinion is, don't attack either side, no matter what people think. We can debate it, but let's be nice about it. So thank you for that. And yes, I make it a safe place for everybody here, no matter what your opinion is on the case itself. Let's just be good with each other. The Idaho arrest warrant could not have given police in Pennsylvania the authority to enter the home. And this is where I'm kind of, I don't know, because I know here in Canada, no matter where that arrest warrant is issued, it's for the person, not the place. So if they see you go into a home, they have the right to go in that home and get you, especially for red drums, right? That's the law here in Canada. I don't know if that's the same as in the States. I believe that, I don't know. I'm going to say for once, you guys, I don't know. Okay. Federal and Pennsylvania law enforcement violated Mr. Kohberger's Idaho and Pennsylvania constitutional rights by not knocking and announcing their presence and presenting Mr. Kohberger with the opportunity to surrender. They're not going to do that when they have a warrant for the arrest of somebody who's being accused of taking the life of 4 students in the most gruesome way possible and horrendous way possible. Right? Where were we? Like I said, they're not going to go to somebody who they think has taken the life of 4 college kids in the way that their lives were taken. It had to have been a gruesome scene, you guys. And what? Go up to the door? Come on now, get some coffee and donuts. Let's have a chit chat. No. They know he's also got weapons registered to him. Then no, they went in the way that they should have. A no-knock warrant. Okay. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally admitted misinformation again. This is where they're bringing up the IGG again. Whenever you see this warrant recklessly or intentionally omitted material information, they're talking about the IGG. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. Here we go again. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genealogy, and thus nothing in the warrant should remain. Information about the client's locations taken from his phone must also be excised due to being gathered from an invalid warrant. Statements after arrest are either fruit of the poison tree, which means they were made before he was given his Miranda rights, from the illegal arrest, or should be suppressed as Miranda violation. Now, I don't know when he was given his Miranda rights. I would assume as soon as they started putting the cuffs on him, they would have said, you're under arrest. You have the right to remain silent. I'm sure they would have done that, and body cam is going to show if they did that or not. Yes. And as you notice, Grammy, that's not being talked about because it's mute. It's already been, like I said, this stuff is under seal. We're not going to hear about it until trial. But those different samples or DNA that was found has already been investigated. And that's why Ann Taylor's not mentioning it anymore, because it's mute. Midnight Baker, please mask your words. I have to remove your comment. Mods, please watch for people using the M word and words that they're not supposed to be using. You got to mask those. I don't need to get demonetized for, and Kezi Kaz, please. I'm going to have to remove that. You can't use the M word. We use red drum or mask the word. I'm just going back a little bit in chat, you guys. I've got to remove those because if not, YouTube doesn't like certain words. Okay. Yes, please mask those words like the pew pew and the e and the deaths. You can't use the M word. Oh no, it's okay, Kazi. I'm not sure if you've seen that in other chats, but yeah. And YouTube just gave us creators some more rules we got to go by, and I haven't even read it yet. If you want my honest, I haven't read it. I'm supposed to. It says read immediately. I didn't. I know I'm a rebel. But yeah, what I have read, there's things that we can't say because they will demonetize. So that's why I asked, please just either mask the words, change a couple of the letters, or use red drum or deaths, like, unalive. Give me 2 seconds, you guys. Okay. Just put it there, please. I will get to it when I'm done this. Sorry, I've got somebody here in the background, you guys. I'm very sorry. Okay, here we go. So we talked about this, about his phone. Statements after arrest are either fruit of the poisonous tree, which means statements that he made before he was given his Miranda rights, due to the haphazard way in which, what a word to use, haphazard way in which law enforcement has kept and disclosed records in this matter. The following are the facts relating to obtaining the search warrant for, why is there an F here? See? Like I said, you guys, here's my legal stuff coming out of me again. 30 years in criminal law. I hate when I see this. Somebody making spelling errors or just stuff like that. I don't like it. Lamson, there's just too many tools, especially out there nowadays, that this should never happen. This mistake. Okay. On December 28th, Trooper Larry of Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via Moscow police. On December 29th at 4:44 p.m., a magistrate in Pennsylvania issued a search warrant. Right? Didn't she just say up here? Hang on. Here we go. Pennsylvania law enforcement violated Mr. Kohberger's, we're reading this. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his parents' home without a valid local warrant. And this is why I said you can't take what Ann Taylor says to the bank, okay? Because right down here, it says a magistrate in Pennsylvania issued a search warrant for 119 Lamson Drive, his parents' house. His parents' house. It's right there. There was a warrant issued by a magistrate in Pennsylvania. On December 29th, the magistrate in this matter signed an arrest warrant for Mr. Kohberger in Latah County. The affidavit for the warrant was signed by Moscow. Right. The basic facts Bleeker used to support the search were, here we go. Oh, she does. But it's just good because we've got, in her own filing, she just says there was no warrant issued in Pennsylvania to search his parents' home. But then she says right here, a magistrate in Pennsylvania issued a search warrant for his parents' home right there. Anyway, next to the body of Madison Mogan was a tan leather knife sheath. The Idaho State Lab later located a single source male DNA. Which means there was nobody else's DNA on that knife sheath. There was one male source of DNA. We don't know what the source was. Was it some blood? Was it some skin? Was it sweat? Was it saliva? Was it spit? Was it whatever? We don't know what kind, but we know that there was a male DNA on the button snap of the knife sheath. Footage from the King Road neighborhood, here we go, showed what police suspected was the vehicle of the red drummer, right? This white sedan lacked a front license plate. A vehicle specialist decided based on the footage that the vehicle was a 2011 to 2016 Hyundai Elantra. A vehicle matching that description was spotted via surveillance in Pullman. It was later discovered that Mr. Kohberger drives the Hyundai and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. The same specialist indicated the car seen in Pullman was a 2014 to 2016. Witness Dylan Mortensen, we've already heard this, indicated that the height of the person she saw was between 5'10" and 6 foot, had bushy eyebrows. That fit Kohberger's description. Here we go about how they got his phone number and everything and started investigating even before they got the other information back. Mr. Kohberger changed his vehicle registration. Cell tower records did not show Mr. Kohberger was in Moscow at the time of the red drums. In law enforcement experience, however, people committing crimes typically turn off their phones. So she's admitting that. And they have his vehicle on CCTV, leaving Washington, crossing into Idaho, going in front of some businesses on its way to Moscow, and then turning off the phone. But it's still seen on CCTV, continuing on into Moscow. Okay, so here's all the other data. Again, I'm going to say it before. They have all these times that he had been going into this area around 1122 King Road, 12 times, they say to be exact, before the red drums. And around the time of the red drums, he had been going around that area. And Ann Taylor said he could have been going to a nice restaurant that he liked or seeing a friend. But after the red drums happened, he never goes back ever again. In the rest of the almost month that he was there, it was a month, he never goes back to that area ever again. So if he was going to see a friend or just going to a restaurant and totally had nothing to do with this, why isn't he still going there? As of the time of the red drums, he stops going altogether. Boom, no more. Little iffy. Okay. See? That same team determined Mr. Kohberger had been to Moscow at least 12 occasions prior to the event and that he came into the area the morning following the murders. Okay, we've already read all this. Okay, here we go. Pennsylvania SWAT raided Mr. Kohberger parents' home on December 30th. During the raid, law enforcement broke the front door of the home, shattered the sliding glass door of the basement, held the entire family at gunpoint and seized Mr. Kohberger. We didn't know this. I thought they just broke the front door. Mr. Kohberger made statements to his arresting officers. He was transported to a police station in Stroudsburg, PA, and made statements even during the transport. At the station, Mr. Kohberger was processed, during which police collected information about his person. Finally, during interrogation, before requesting an attorney, Mr. Kohberger made statements to interrogators from the Idaho State Police and the Moscow Police Department. So, he made, and we know, like when they put you in that room, when they arrest you, they read you your rights. When they put you into that room, usually if the arresting officer is in that room with you, there's usually a detective on top of that. The detectives don't usually go and do the arrest. The SWAT team did. SWAT team arrests him, reads him his rights, puts him in twist ties or whatever they did, throws him in the back of a car. He's read his rights. When he gets to the police station, they throw him in a room. Not throw him, you know what I mean. They sit him in a room. Usually it's detectives that come in and they, again, read him his rights. You have the right to remain silent. Everything you say can and will be held against you. You have the right to an attorney. Do you wish to speak to us? So apparently before requesting the attorney, so obviously she's going to say that he was never read his rights. But she says here, Mr. Kohberger made statements to interrogators from the Idaho State Police. Finally, during interrogation, before requesting the attorney. So he was read his rights and he was talking to them, and then he decided he was going to request an attorney. Mr. Kohberger made statements to interrogators from the Idaho State Police and the Moscow Police Department. So Moscow and everything was there. Idaho and Moscow was there. Woo. At 4 a.m. on December 30th, Pennsylvania State Police filed a criminal complaint against Mr. Kohberger. Their argument: this court should apply Idaho's exclusionary rule and law to this search, which is, again, the IGG. Okay, so I'm scrolling through this. She's going to mention all these other cases, blah, 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 blah. And her whole thing is he never should have been arrested to begin with because they arrested him based on IGG. Kohberger has standing to challenge the search of his parents' home. Mr. Kohberger grew up in his parents' home, and because they're saying that he doesn't have standing, which means he doesn't have the right to fight or complain about the entry into the parents' home because it's not his house, it was his parents. But she's saying that he grew up in his parents' home, even though he was no longer living there, which gives your rights away because you don't live there anymore. But anyway, they're saying that he still has standing there because he grew up there and that he was visiting at the time of the entry and he was staying there for winter break as an overnight guest. He undoubtedly has standing to challenge the search in this case. And then they violated his Fourth Amendment rights by entering and searching his parents' home without a valid local warrant. They did. The Pennsylvania judge issued the warrant to go in. We've seen that. So you guys can read through this all if you want. But there was some things in here. The need for a warrant for a fugitive from another state is codified without a governor's warrant. An officer can get a judicial warrant to permit entry, which they did. Federal and Pennsylvania law enforcement violated Mr. Kohberger's Pennsylvania and Idaho constitutional rights by not knocking. Well, those laws are in Idaho, right? Federal and Pennsylvania law enforcement violated Mr. Kohberger's Pennsylvania and Idaho constitutional rights. Well, Idaho constitutional rights are not applicable in Pennsylvania by not knocking, announcing their presence. Well, you do a no-knock warrant when you have a fugitive that has taken the life of 4 people already. That's a no-knock warrant, okay? You guys can Google stuff like that. There's usually if it's a misdemeanor or something, they'll knock on the door. It's like, okay, look, he didn't show up for this traffic violation. We need to speak to him. But when you are going to arrest somebody who took the lives of 4 college students in a brutal, horrific way and has fled the area, and you know he's in that house, yes, it's called a no-knock warrant. Similarly, it says upon suppression where the knock and announcer rule has not been complied with absent of exigent circumstance. What? The Pennsylvania Supreme Court has only found 4 exigent circumstances permitting police to ignore the knock and announce rule. The occupants remain silent after repeated knocking and announcing. The police are virtually certain that the occupants of the premises already know their purpose. The police have reason to believe that the announcement prior to entry would imperil their safety. Yes, because they've already researched him and know he has guns. Pew pews. The police have reason to believe the evidence is about to be destroyed, and he could have done stuff like that too. So these are the reasons that they can do a no-knock warrant. They had reason to do a no-knock warrant. Okay. I don't believe one word from Kaylee's family. They have milked this case for every dime. Okay, let's not. Okay, that's where I draw the line. Let's not attack the family. We do not do that here. Kezi, please don't do that. We don't attack victims. You can have your opinion on that, but please don't do that here. Oh, they're milking. Because I've seen so many YouTubers attacking them. Like, they got to pay for stuff that they never ever thought that they would ever have to pay for. It's going to cost them tons to come and get motel rooms and everything to be here for these hearings and trial and everything. Please, let's not attack the victims. That's one thing I do not will not allow here. We do not attack the victims. Okay, because Jeff H, I got to remove that. You can't put the K word, the Kill word. You can't use that. You got to mask it, hon, please. Mods, can you please watch these comments? And I've got to go through it and do it now, which puts everything on hold because it takes, once I end this live, YouTube gets it and starts processing it. And if they see this stuff in there, then they demonetize my video. So let's not attack the victims. Please do not do that. I'm going to remove all your comments that are doing that. I'm asking from here out. If you do that, then I'm going to put you in timeout. Kezi, please stop. I just removed your comment where you said about Kaylee's family defending Jack D. Please, I'm going to ask this last time. Do not attack the victims or their families. Stop. Stop. The last time Kezi, I've given you more than enough opportunity to say, and I've allowed you to have your opinion, but when you start attacking the victims or their families, no, that's where I draw the line. Please stop. Thank you, Rose, for going through and taking those out. I appreciate you. Unspoken butterfly. Hello, my love. Okay. Now, where was I? Let's get back to this. Okay, so I do believe that the police have reason to believe that an announcement prior to entry would imperil their safety. Yes, because when they did look into Bryan Kohberger, they knew that he had, I don't know what you call it here. Here it's an FFC, a concealed carry. Maybe he had something along those lines. Yes, Kezzy, I will, but just please, I will do that for you, but please stop bashing them here. I will not put up with that. I'm asking you, please, because I don't want to ban you or anything from commenting. I like hearing your thoughts, but let's not attack the family or the victims, please. Okay, let's continue. Idaho's understanding of the knock and announce rule is set out in Roch. It doesn't matter. They're not in Idaho. We're not in Idaho anymore. We're in Pennsylvania, and those are the rules that we go by. And those are the rules for Pennsylvania, and they followed that. In this case, there is an okay, wait. Mr. Kohberger had been surveyed. See, now they're going again. Now they're saying weeks. In their last motion, they said that the FBI had been surveilling him for days. Now they're back to weeks. At no point during the surveillance was he seen to have any weapons. Well, they could have been concealed, but they do know that he had permits for a couple different guns. So there's no reason to take him inside the house, as surveillance undoubtedly was aware of his daily runs. The evidence police thought was simply not of the kind that giving him a chance to exit the residence would have imperiled. Well, you don't know if he's carrying that on him, and an officer could have been hurt if they tried to. He's running. You're saying that he goes for these runs. If they got to run to catch up with him or pull out with cop cars in front of him, he could take that pew pew out and start firing. So this is why they do it the way they do here. Like if you are being arrested for serious offenses here in Canada, they wait till 3, 4 o'clock in the morning till they know you're asleep. They put, they fire these loud bang things into your house first. I've seen them blow out a side of a brick wall to get into a residence. So, and they do that so they catch you off guard. Anyway, so if you guys want to read through all these cases that she's mentioning, go right ahead. Affidavit submitted in support of the application for the issued search warrant recklessly or intentionally admitted material information. Here we go again. Guess why? It's going to be based on the IGG. Right? Again. Right? Because they're saying it was based on the probable cause. That probable cause was based on blah, 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 blah. And guess what? It's going to all come down to the IGG again. And you'll read it if you want to read through all that. But it's all coming down to the IGG. See, here we go. The affidavit submitted in support of the application for the issued search warrant included information that must be excised, where the information in the warrant was obtained via violation of the Constitution of Idaho. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. There we go again. So they want this warrant gone. Everything gone. Everything gone. Information about the client's location taken from his phone, they want gone. Statements after arrest, either from the fruit of the poisonous tree, from the illegal arrest, or should be suppressed as per Miranda. So like I said, if you guys want to read through all these cases that she cites, Mr. Kohberger was zip-tied after a no-knock warrant was served. He was zip-tied at his hands and surrounded by police at gunpoint. Law enforcement did not Mirandarize him immediately. Well, no. They secure him. They arrest him. They get him out of the house and get him in the cop car, or as they're searching his body for weapons or whatever, then they tell him, okay, here's your rights. Instead, they waited till after he was transported in a police car and cuffed. handcuffed with at least 2 officers in the car. One was seated next to him in the back seat. I hope there's body camera of them giving him his Miranda rights before he was put into the car. Defendant was in custody for purposes of Miranda when he was questioned while handcuffed and restricted the area of the patrol car. Now, if they haven't given him his Miranda rights, which I don't believe that they didn't, I think they should have body camera to show that they did. Anything that he says in that police car, we've seen it on the Stephen Stearns when he's in the back of the police car talking to the cop. Hello, anything you say can and will be used against you, including what you say in the back of the police car. A reasonable person in Mr. Kohberger's position would have understood himself to be in custody. Now, they could have said that they had detained him and they were bringing him in and told why he was, I don't know. We'll have to watch for the video camera. 2 conversations took place before Mr. Kohberger was Mirandized at the police station. It is clear from the police station video that the detectives asked him if he had ever been Mirandized before, and he said they needed to go through the formality of Mirandizing him. He said no. So which means, like, have you ever been arrested before where you've had to be given your Miranda rights? That's what they were asking. She's making it sound like he wasn't given his Miranda rights when he was arrested. I think the way that this was, have you ever been arrested before and needed your Miranda rights to be read to you? And he said no. No video or audio recording of the entry into the home and initial arrest has been produced. Video and audio. See, this is the FBI. This is the FBI. The FBI doesn't have to give up that information. Good luck trying to get that. I know the prosecution has been telling the FBI, look, we need certain things. And the FBI goes, sorry, ain't giving it to you. You can't force them. You cannot force the FBI to give you these things if they don't want to give it. So, the conduct of the officers, nature and manner of the questioning, the conduct of law enforcement, Mr. Kohberger in the house referred to as small talk when he was being recorded during transport. This cannot be verified because no audio video is produced. The conduct of the officer in the police car during transport cannot be described as an interrogation. However, without a video or audio recording of in-custody discussions inside the house, the true nature of the statements made in the car are without context. All statements made at the police station were post-Miranda, information in the media right after arrest, and attributed to law enforcement report that Mr. Kohberger, that's the statement that he had made. Has anybody else been arrested? Such as statement is not in a police report or in an audio video recording that can be found in discovery. If it is a statement that the state will seek to attribute to him at trial, it should be suppressed as a non-Mirandized statement. If the conversation with Mr. Kohberger inside the house was custodial in nature, that context may warrant suppression of the conversation in the police car during transport. So, Mr. Kohberger requests this court to suppress all evidence obtained by police via the warrant, okay? This is what he's doing for all of it, okay? Now, I'm going to show you, we haven't gone over even a quarter of what she has filed, and we've been at it for 2.5 hours. So, we went over the motion for leave. We went over the motion for the Franks hearing. We went over the motion to suppress the genetic info. Now, we went over his apartment. We went over a few of these, the White Hyundai and his parents' address and the warrant. Now, they are also saying the same thing about the warrant for Amazon, the warrant for Apple, the ATT warrant, the cell phone data warrant, the Google warrant, the pen trap trace device warrant, person in Idaho, person in PA. Those warrants, all she said is using the same argument. They should be thrown out. They shouldn't be used because of the way that they use the IGG. So we are not going to go over. We've gone over these warrants before. We all know what they're about. The Amazon shows the purchase of the K-bar. There's other things that were in his apartment, which is covered here, where there's receipts for the clothing and stuff like that, where there's an animal hair found. stuff like that. We've gone over all those warrants already. So just to let you know, she wants every piece of this evidence and warrants expelled, including his arrest warrant, because of they used IGG. So with that being said, I am going to wrap it up because I think 2.5 hours is a lot of time to go over this. I went over the main ones. Like I said, the cell phone data, the Amazon, the Apple. We've gone over those warrants before. She's using the IGG to try and get those warrants thrown out and the evidence from those warrants thrown out because he never should have been arrested to begin with as per IGG. Everything comes back to the IGG. All of these motions to suppress are hanging in the balance of 1 or 2 hearings. The motions on one hearing is the motion, the Franks hearing, and the motion to suppress the IGG info. So if she loses her battles on the Franks motion and the motion to suppress the generic info, if she loses, if these two are denied, she's not going to win on any of these because all of these are based on it was against the Constitution to arrest him and illegal arrest because they were led to him by IGG, which is unconstitutional. So if she loses the Franks hearing and the motion to suppress the IGG, then she loses all these too. So I do believe that there was already a ruling on the IGG, and I believe that it was going to be allowed as the prosecution showed that there was many cases that they used IGG, and it was allowed in for trial, and it was allowed in as evidence in other cases. I believe that it went to the Supreme Court, and the Supreme Court said it's fair game. We'll have to wait and see what this judge says with it. I believe that Judge John Judge had already made a ruling on this, but she's trying to get it in front of Judge Hippler. Judge Hippler, as we can see from this one right here, he's very upset. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. The state's discovery deadline was September 6th. They met that deadline. The defendant could have asserted far sooner whether the discovery motions deadline would pose difficulty and brought it to the court's attention. The defendant has not demonstrated with his filing good cause to enlarge the deadline. So right now, she's in violation of the deadline because she didn't file the discovery motions before November 14th. She wants more time. And the judge is saying, absolutely not. You're not going to file this in the late afternoon of November 13th when your deadline is for November 14th. And you file late November 13th asking for an extension or a motion for leave. Right? And he calls it the defendant's naked motion for leave, right? Oops. She pissed him off, and I don't think a lot of this stuff is going to bode well after peeving off the judge, right? Okay, let me get, where is my, oh, it's over here. So let's stop. So that's what I got for you guys. I'm going to close this out so I don't get booted. Oh, so my screens don't go black. It's because I had so many different screens open. So that's what we're going to go over, you guys. If you do want to scroll through and look through it, if you guys want to go, I mean, we've already gone through those warrants for Apple and Google and Amazon and this and that. We've already seen them. We've seen what was the list of what was taken from his house, his parents' house. We've already done all that. I don't think we need to do it again. I feel like it's just like milking things here. I went over the newer things that are out, so you guys know where things are standing. I do believe Ann Taylor is beating a dead horse here. A lot of things here, yes, she has to do to have it on record in case it's going to be appealed anyway if he's found guilty. Um, and I think she's getting it on record for that cause in case it is appealed. Drink some hot tea. Yes, I do have some. I do have my, here. Oh, my camera is not even up, so I can't even show you. I do got a mug right here of coffee. So I've been drinking that. And again, Rose, thank you for your super sticker. I appreciate you. And all those that did hit the like button, thank you. It does help. I know sometimes people can't afford to give the super chat, super stickers. It helps the channel. So if you can afford to, I appreciate. If not, at least hit that subscribe, hit the like. It helps just as much. So I appreciate each and every one of you for doing so. It like I said, if you can afford it, great. If you can't, please hit that subscribe and hit the like button. It helps out, and I'm just as grateful for those things also. So with that being said, you guys, I'm going to wrap it up. We've been here for 2.5 hours. I don't want to take any more of your time today. It's going on, 20 to 4 here Eastern. I got to get something going for dinner. But I wanted to bring it to you guys. I want to show this judge is not impressed with Ann Taylor. Not impressed at all. So let's see what happens. He hasn't had a chance to respond to the hearing that we watched. Okay, we had that Bryan Kohberger hearing on the 7th. There's still no orders regarding that hearing. And now she's thrown all this at him. He's not going to be impressed, right? So tomorrow, you guys, live mini reads for you guys. If you guys ever wanted a mini read on yourself or you want a question answered, join us tomorrow, 1 p.m. Eastern, where I go live and I do mini reads for you guys. I will ask a question. We'll let the cards answer for you. Mini reads live tomorrow, 1 p.m. Eastern, right here with yours truly. And a lot of the mods are there too, so you can come in and chit chat with them. And, if we forgot to mention something today, you could bring it up then too. And because we do a little chit chat session before we start the reads, that gives everybody a chance to get their request in for their mini read. So that's 1 o'clock tomorrow afternoon, Eastern, right here. Usually in the mornings around 9-10 o'clock Eastern, I put up the thumbnail so you guys can set a reminder for the mini reads, and that's where you can get your very own mini read. So for those of you who are going to show up, I will see you tomorrow, 1 p.m. Eastern. And for those of you are here today, thank you so much. For those of you who have given the super stickers and super chats, thank you very, very much. It helps. For those of you who have liked and subscribed, thank you. I appreciate you. Even your comments and your chat and our different opinions and keeping this safe for everybody, I thank you. I thank you so much. You guys are the best. You rock. So until tomorrow, 1 p.m. Eastern, I'll be here. Come and get your very own mini read. I'll see you guys tomorrow. I'll end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Bye-bye for now.